Yo, shout it out, y'all. We locked in, man. What's going on with everybody out there, man? How y'all doing, man? I'm your host, Moshe Canty. Um, it's good to be here with you guys. I'm glad that I had the opportunity to be able to pull up with you. I just want to kind of share my thoughts with you regarding the Supreme Court's decision to deny state prisoners the rights to argue a very probably one of the most argued claims that prisoners raise when they're locked up and stuff like that. And I think that this is important for a number of reasons. Um, I want to get right to it. I don't want to waste time. I know it's late in the day. Many of you guys are probably coming home from work, if anything. Shout out to everybody who's tuned in. Everybody that's out there, thank y'all for your support. We truly appreciate it. Um, but I just want to get right to it. So back in May, um, the Supreme Court they heard a case that was regarding two individuals who were on death row. New Black World Order, shout it out, my brother. Salute to you as well. And the case was pretty much centered around state prisoners who are challenging that their state criminal attorneys were ineffective. Most recently, the Supreme Court just ruled that in a 6-3 decision, obviously was along ideological lines. And what I mean by that is that the 6 individuals um, who argued against the state prisoners' rights were individuals like Clarence Thomas, Neil Gorsuch, Justice Bennett, Justice Kavanaugh, Justice Alito, and Justice Roberts. And in the minority were Justice Sotomayor, Justice Breyer, and uh, Justice Kagan. So it was a 6-3 decision. So anytime you have these decisions that are taking place in the Supreme Court, a lot of times it's really Jose Montalvo, shout it out, Jay Renee, shout it out, Sadie B, locked in. So when you hear that these decisions are happening, more than likely it's happening along ideological lines and stuff like that. So this decision is no different, right? And if I'm not mistaken, the case was about 2 individuals on death row who they argued that essentially that their trial lawyers were ineffective. They went through the courts. Somewhere along the line of them arguing these claims, for the most part, it got to the Supreme Court. The Supreme Court granted writ of certiorari, which in this case allows the court to hear what the argument is, and most recently they basically denied it. The Supreme Court just recently overturned or denied state prisoners, the rights to be able to argue that their trial lawyers in this case, were ineffective. And why is this significant? Why is any of this important? Why are we even having this conversation on We Locked In? One is a disproportionate number of Black and brown bodies who occupy prison cells across America. This has always been the narrative. This has always been something that has been propagated from day one, since many of our ancestors were forcibly removed and brought over here. It seems as if this is the common norm. So this is something that we should definitely take into consideration. But I want to kind of read some of this information into the record so I could provide some backdrop regarding this, right? So that individuals will have just a little bit of understanding. And for the record, I'm reading from NPR. And I just want to give you guys just a complete picture of it so that nothing is like left out in this. So I'm going to read the article, and then I'm kind of like going to be responding like in the midst of me reading and stuff like that. So it says that, and first, for the record, again, this article itself is by Nina Tottenberg from NPR, National Public Radio. So this is, in the title of it is called Supreme Court Hobbles Challenges by Inmates Based on Poor Legal Representation. So the United States Supreme Court ruled Monday that state prisoners have no constitutional right to present new evidence in federal court to support their claims that they were represented at trial and on appeal in state courts by unqualified or otherwise deficient lawyers. The vote was 6-3 along ideological lines, as you guys heard me state already. Dial tone, peace, my brother. In 2012, the court ruled that when a state court, quote, substantially interferes with a defendant's constitutional right to be represented by counsel, the defendant with a new lawyer may appeal to federal court to show that he was denied his right to effective counsel. So what happens for individuals who are not aware of the process, I get locked up while I'm, let's say for instance, I'm challenging my charges that I've been incarcerated for or detained for in this case, right? My lawyer, I say I want to go to trial. I want to face a jury of my peers, or I would prefer to have a judge try me during this trial. You have that right? So in this regard, I will be essentially judged by either the judge or a jury in this case, right? And the reason why this is important is because you're exercising your quote unquote your rights. We all have rights, right? So you're exercising this right in this case, right? So if your lawyer in this case is not representing you in an efficient way or an effective way, if you happen to be found guilty at the trial stage, you then have an opportunity when you file an appeal, because that is another right that you have. After you're found guilty and you're sentenced to whatever the sentence is, and you go upstate, if you don't have the financial means to be able to pay for a lawyer on your own, then one will be appointed to you, not only at trial, but on the appeal stage as well. So what happens is that you have what's known as an appellate attorney. An appellant attorney in this case, they look at the trial record and they want to see whether or not there are any infirmities in your defense, if there were any legal constitutional violations that may have occurred on the trial level. So they're just literally examining the record. A lot of times your trial lawyer is supposed to be objecting to many of these trial related violations, constitutional violations that's taking place, so that it affords the appellate attorney an opportunity to review the record. And the trial attorney in this case is doing what's known as preserving the record. All right. And the reason why this is important is because the appellate attorney now would be able to look at these violations, and because the record essentially has been preserved, he or she now then can argue these issues on appellate level, right? But what happens at trial a lot of times is that the trial lawyer does not properly preserve the record. So in doing so, they kind of invalidate and emasculate. They weaken a defendant's chance of either beating the case at trial or perhaps having their case overturned on appeal. So in the event that your trial lawyer fails to do so, it's your appellate attorney's responsibility to argue that your trial lawyer was ineffective for failing to raise issues that could have potentially granted you the relief that that obviously the defendant in this case was seeking, or the defendants in this case were seeking. So in this case, as I just read, I'll read it again. In 2012, the Supreme Court ruled that when a state court substantially interferes with a defendant's constitutional right to be represented by counsel, the defendant with a new lawyer may appeal to federal court to show that he was denied his right to effective assistance of counsel. So in this case, the law is clear back in 2012. So, but back then the majority was 7-2. But again, it was along ideological lines. 7-2 because they ruled in favor of defendants. They ruled in favor of state prisoners, individuals who had already been found guilty, individuals who were already incarcerated, etc. Right? But back then, Justice Thomas was a part of the minority. He was one of two individuals who dissented in that decision. On Monday, however, or back in May, Justice Thomas, he wrote the majority decision for this new case, and he pretty much hollowed out that 2012 ruling on behalf of the court's new 6-justice conservative supermajority. So in alignment with the 5 other justices who make up the conservative bloc on the United States Supreme Court, Justice Thomas in this case, they literally gutted out that 2012 ruling so that it's no longer law. Now, the law that they're going to establish now becomes the law of the land as it pertains to this particular issue. Why is this important for us? Because again, our people, black and brown bodies, are disproportionate being locked up at every level in this country, at every level. I'll get back to that. But this is what Clarence Thomas said regarding this ruling. He said that federal courts may not now hear, quote, new evidence obtained after conviction to show how deficient the trial or appellate lawyer in state court was. Why can't, Justice Thomas, why can't a federal court not hear new evidence if the evidence could help exonerate somebody? Right? This just doesn't make sense. All right. He says to allow such evidence to be presented in federal court, he said, quote, encourages prisoners to sandbag state courts, depriving the states of the, quote, the finality that is essential to both the retributive and deterrent function of criminal law. What the hell is he talking about? The issue is whether or not, in this case, a trial attorney was ineffective. Was the trial attorney ineffective in performing their duties? And if they were, perhaps you were not able to have information at your disposal that you could basically claim so that a state court could review that matter. Perhaps you didn't have information. Perhaps you were incapacitated. Perhaps, and I'm not going to say this because even ignorance of the law is not a defense, but perhaps in this case, newly discovered evidence came about that you were not able to acquire at your trial. I'm going to give you an example. So let's say, for instance, that you had no knowledge that your trial lawyer was collaborating with the district attorney, and the district attorney told your lawyer at trial, listen, I'm going to be willing to give your client 5 years if he or she pleads guilty to this case. This is a discussion that your lawyer and the district attorney is having in private, right? But the third party is there, right? And that third party just happens to be somebody who is a fair and impartial person from the district attorney's office, right? This is the ADA trying your case and their assistant, and then your lawyer is there. Your lawyer is assuming your lawyer is ineffective, but the DA is talking about only giving you 5 years, but the assistant is standing there. You would think that this information is not going back and forth, but it actually happens all the time. The DA says to your lawyer, I will be willing to give your client 5 years for this case. But if that person goes to trial, I'm going to up the ante on them, right? So they say, I'm going to up the ante on them. Now, the person goes to trial and get 35 years. This happens all the time. There's many black and brown bodies up north with 30, 40, 50 years. And all they had to do was take a plea bargain. But because they forfeited that plea bargain, they got a whole bunch of time in prison. But now, as time goes on, you don't know that this conversation ever took place between your lawyer and the DA. Because what happens now is your lawyer just basically tells you, yo, we could beat this case at trial. The case looks weak. The case look weak. You end up being found guilty later on. But somehow, by the grace and mercy of Allah, that ADA's assistant becomes a defense attorney. How this happens? It happens all the time. Their mindset of locking everybody up changes. They now become defense attorneys where they want to represent people at trial. Their conscience starts getting the best of them. And they say, I remember I prosecuted a guy years ago, and they just they mistreated this person. So as you're filing your appeals all the way up north, you're putting cases in the courtroom, you hear from a lawyer out of the blue. From a lawyer out of the blue who used to be a DA. They write you and they say, listen, your lawyer didn't represent you at trial correctly, because during a private conversation with the DA, your lawyer was told that if you pled the 5 years, they will give you that 5 year conviction. That 5 year bid. Well, if presented with the 5 years and you don't take it, you're going to get 35 years. Your lawyer never told you that. Now, mind you, why is this important? The reason why it's important is because you never had this knowledge. And perhaps if you knew this information, if your lawyer conveyed this information, perhaps you wouldn't have rolled the dice and took it to trial. You'd have took the 5 years. So that makes it very significant. A lot of individuals are sitting up in prison right now because their lawyers never conveyed this critical information to them. Again, this is very important. So now you get this newly discovered evidence from this new attorney now. You have an evidentiary hearing, meaning you put a 440 motion, which is a post-collateral motion, which allows you now to argue new evidence that you didn't have at your initial trial. How would you know that this occurred without this information coming? That new assistance now is a defense attorney. They testify at the evidentiary hearing. They say, while I was an assistant to a district attorney, I overheard this information being conveyed by the district attorney and his trial attorney. It was never conveyed to the defendant. The trial judge says, you know what? Although this information came out, I'm still going to deny his right to have his conviction overturned, or whatever the case may be like that. You now, as the defendant, you appeal the denial of your 440 all the way up to the state court. The state court denied. You appeal it to the highest state court, which is the New York State Court of Appeals. And then once that's denied, then you say, you know what, I'm going to file what's known as a writ of habeas corpus to the federal court. As you get to the federal court now, your argument is that because I was denied my federal rights under the Sixth Amendment, which is to have a fair, an effective attorney, a trial of your an attorney of your choosing. You expect that attorney to be effective. That's your Sixth Amendment right. Now, what the Supreme Court decision is saying is that new information that you got from that attorney who was once a DA, you can't argue that no more in federal court. That once the states do away with it, that argument then can't go to the federal court to allow the federal court an opportunity to review that issue needs to be overturned. Does this make any sense? Like, for real. Why is it that if the states can't rectify that matter, the feds don't have the authority to be able to say this person's Sixth Amendment rights were violated? His trial attorney knew that this conversation was private, and he should have, as an effective attorney, conveyed this to the defendant. But he failed to do it. Somebody else revealed that this behavior took place. There's no doubt that the law is clear that this behavior is ineffective assistance of trial counsel. But the Supreme Court is saying that the states now have to deal with that matter. And when that matter becomes final, it can no longer go upstairs to the federal courts, and it can no longer go upstairs to the Supreme Court. Why is this serious? How many black and brown bodies who are sitting in prison right now do you think will be adversely impacted by this decision? America incarcerates black and brown bodies. Forget black and brown bodies. It incarcerates people more than any industrialized nation on the face of this planet Earth. It incarcerates people at a rate that the world has never seen before. This is the most incarcerated country that has ever existed. The people who are incarcerated, just for the record, black people, so-called African Americans. Let me not say black. That's probably not accurate. So-called African Americans make up about 13.9% of the population, but yet make up majority of the populations in prison. Can somebody please explain to me how was it that so I'm gonna simplify this, right? How was it that out of 100 people we were in one room, take 14 people out of that 100 group, 14 to go over there. Now you got 86 people on the other side of the room. It's 14 over here. Does it make sense to me that in prison, majority of this 100 people are black? Mathematically, it just doesn't make sense. Logically, it just doesn't make sense. How is it that this small percentage of people who make up the 100 people, how is it that they overpopulate everybody in that group? So this is what we're getting at. This is why there are undertones, racial undertones, and why people are always arguing that the United States criminal justice system is very racist. Let me start pulling you guys. I see some comments in the chat. I just wanted to get this conversation going. I wanted you guys to have an opportunity to see what's taking place right before our very eyes with the United States Supreme Court. Over the last couple of weeks, we've seen what take place. The rights of women just being trampled upon with the abortion argument, right? Again, this is a 1973 case, Roe versus Wade. We're now in 2022. 50 years ago, this was the decision of the courts. Now that decision is a wrap. We've seen that take place, right? Recently, a decision in New York, the Supreme Court ruled that concealed weapons in New York is unconstitutional. All right, so now if you have a gun license, you can't even carry a concealed weapon in New York no more. But again, back in May, they just ruled that individuals essentially cannot argue that their state attorneys were ineffective on a federal level. If the state courts, whether it's the lower court, meaning the trial court, where you may argue what's known as a post-collateral motion, because after you get convicted in the state of New York, it's called a 440 motion, right? You have a right to under CPO 440 to argue that your conviction is unconstitutional, right? So it's called a post-collateral motion because it's happening after the fact that you were already incarcerated, already convicted in this case. So the argument is, if the states do not finalize if the states do not rectify the issue, where do you go? Where are you going to get justice from? If your constitutional rights have been violated, where are you going to get the justice from? It could potentially be that your rights were violated. You're sitting in jail, you're innocent. And even if you're not innocent, the fact of the matter is that everybody has a right to an effective trial attorney. But in many instances, especially Black and brown bodies who are indigent, individuals who don't have the resources to be able to defend themselves in court or obtain the necessary representation to defend themselves, investigations are not being done, alibi witnesses are not being questioned. A lot is happening before you actually have a case tried in court. And when you lack the resources, an indigent or court-appointed attorney is not going to represent you in the most effective and impactful way that's going to help you get your, help you really, really, really acquire and obtain your freedom. It's just not happening. It's just not happening. So if you're not able to get this matter rectified at the trial level, because when you file a post-collateral or a 440 motion in the state of New York, when you're doing that, you're going back to the same trial court that you were convicted in. But in many instances, you're going right back in front of the same judge who just gave you 50 to life, who just gave you 100 years. So you're going right back down to court. How you doing, Your Honor? Oh, yeah, you're back in my court. What judge wants to admit that in my court, these constitutional violations occurred, so I'm going to overturn my decision in my court? What judge, does that? Even though it happens all the time. So if that matter is not rectified at the trial level, you can appeal it to what's known as the intermediate court. And in the state of New York, it's called the appellate division. You have 4 appellate division courts in America, in New York. You got the first department, you got the second department, you got the third department, and you got the fourth department. These courts, appellate courts, depending on the department, are positioned in certain jurisdictions. The first department is governed by Bronx, Manhattan, etc. The second department is like Brooklyn, Queens, Long Island, Westchester. The third department is like Albany, Cayuga County. You feel what I'm saying? Not Erie County, but Chemung County and things like that. The fourth department is like Erie County and Chattanooga County, whatever the hell, right? You got all these different type of, but this is how it's broken up into these different departments, right? So depending on where your case was tried at, that jurisdiction ultimately takes precedent when you appeal the denial of a decision from the trial court, from the lower court, which in this case is the trial court. So if these courts, the lower court and the appellate divisions, whether first, second, third, fourth, deny it, again, you can go to the highest court in the state of New York, which is the New York Court of Appeals. That court oversees, it's like quote unquote the Supreme Court of the state of New York. All right. It's the top of the line on a state level in New York. So what the Supreme Court is essentially saying is that if you get convicted and then you try to go back to the trial court to argue that your case or your trial was unconstitutional, and then you go to an appellate court and they affirm the lower court's decision, and then you seek leave to appeal to the New York State Court of Appeals, and all of these courts deny that, in spite of the fact that there may be constitutional violations at all levels of this, because it happens all the time, that black and brown bodies are just being their convictions are being rubber stamped in spite of being innocent and in spite of having many constitutional violations against them. The Supreme Court's ruling is saying that they're going to let the states deal with this matter, and that now state prisoners cannot go to the federal level and argue either in a writ of habeas corpus, or there's no need to go to the Supreme Court to argue these cases, because in the words of Clarence Thomas, he said that this encourages prisoners to sandbag state courts. What does that mean? Sandbag them. This means that at the end of the day, what's going to happen is that the courts are going to be inundated. It's going to be so many motions and so many appeals coming their way. They're not going to have the time, the leisure, the luxury to be able to think straight and to do their jobs, because they're being, overwhelmed with so many. Who cares what you're being overwhelmed with? If people sitting in jail talking about their constitutional rights have been violated, what does being sandbagged have to do with the fact that perhaps black and brown bodies are sitting in prison for stuff that they didn't do? And even if they did do it, that's not the issue. The issue is whether or not these individuals were given adequate representation and whether or not their rights, they were afforded the full panoply of their rights. And if that wasn't done, how can you say that true justice, has been handed to them? But yet these judges are supposed to be fair and partial. Now that ruling did not have to happen. Justice Thomas, Justice Alito, Justice Roberts, Justice Kavanaugh, Justice Gorsuch, and Justice Bennett, shame on you. Shame on you. Because you got what you guys did is wrong, it's unjust, and it's a horrible decision. We locked in. Y'all getting this from We Locked In, man. I don't think I have anything to say regarding this. There's a lot more to talk about regarding this, but obviously, I just wanted to give you guys some clarity regarding. Now, I know a lot of you guys out there that's listening. Most of us have either been incarcerated, or we know our family members who have been incarcerated. We know our comrades who are currently sitting in there right now. Think about individuals who are sitting in there right now. We know people in there right now. We know people who are in the law libraries right now. We know individuals that's doing everything in their power. They're looking for every loophole. They're in the law library, every module, fighting every single day for their freedom. Think about the people that we know who were exonerated, who fought for their freedom while they were incarcerated, and they gained their freedom because it was these legal loopholes that they were able to find in the law library. But some individuals, unfortunately, can't do that no more, because those loopholes, those doors are slowly closing up now. Look what's happening, y'all. What's the real reason why they made that decision? What's the real reason, man? I'm your host, Moshe Canty, man. Y'all listening to We Locked In. Just wanted to give y'all something to think about, man. Hopefully, man, man, we can share with those that we love. Perhaps they may gain some benefit. We can encourage the youth not to replicate some of the senselessness we engaged in as youth, that led us to being incarcerated. Some of our kids right now acting like they don't care. They out there in these streets letting them things fly. They're getting sentenced to 20, 25 years, and they're not going up there with the knowledge about the law. So perhaps we need to have these legal classes, man, before they even get there. So maybe they'll even think twice about getting up in there. I see all my peoples that's in Chat, Clearwater Fresh. I believe we fighting a system built to destroy us, period. They let some slip through, but overall it's rigged. Yeah, you're right, bro. This is the nature of the system. This is the way it was built up from the beginning. I agree. Bilo shot it out all the way from Hawaii. I see Jamel Saladin is in the building. Dow Tone, my brother. New Black World Order, J. Renee. Platinum Mascari, 7112. Zeke, Feed the Wolves, my brother. You already know, man. Shout out to all y'all that's tuned in, man. If y'all was able to gain some benefit from this, please, man, pass it on to somebody who you have influence over. Perhaps it may inspire them to empower somebody else, or perhaps it might even save them from going down a dark and destructive path. Shout out to my brothers, Mikey B, KK, everybody that's tuned in, man. Y'all already know what it is. Jay Renee, I love y'all. Peace.